At Raju Law, we don't just provide legal services. We provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I'm Manshi Katira and I'm absolutely delighted to have you with us for another episode of Immigration for All, brought to you by Narohi Global and proudly powered by Kulna Tech. If you've been tuning in, you already know. We recently rebranded our Monday Live series to Immigration for All, a name that reflects our true purpose to make immigration knowledgeable, clear, accessible, and practical for everyone, no matter where you are in your journey. And yes, we are now officially available on Spotify and Apple Podcast. So whether you are commuting, working out, or just relaxing at home, you can catch all our episodes anytime, anywhere. Let's move on to the today's topic, which is code with many, right? Like we all are stuck in some other things. So, unlocking immigration delays, the power of writ of mandamus. If you are ever experience long waits, radio silence from USCIS, or unexplained processing delays, you are not alone. But what most people don't know is that there is a legal mechanism that can compel action. It is called Writ of Mandamus, and it could be the key to getting your case unstuck. We will break down what it is, when it applies, and how it works. With the help of two phenomenal immigration attorneys who work on these cases every day. So, let me proudly welcome today's special guest, Chelsea Smith and Caitlin Moore, both experienced immigration attorneys and passionate advocates for immigrant rights. Chelsea and Kathleen have helped clients successfully use the right of mandamus to push forward long delays immigration case, and they are here to help us understand exactly how it works. Hello, Chelsea, and hello, Kathleen. How are you?
Hello, doing well. Excited to discuss this exciting topic today.
Yes, thank you for
Yes.
having us.
Yes. So let's dive right in. The floor is all yours.
Perfect.
Okay. Well, as discussed, thank you for joining us today. We are excited to be here to discuss this topic. It's something that's a growing interest for many people in their immigration journey. It's something that, as we all know, the immigration journey can be complicated. At times it can be slow, and then there's times where we can actually compel the USCIS to speed this back up and to get it back on track where there's been different kinds of delays. So today we're talking about writ of mandamus for immigration purposes. And we will begin by discussing exactly, we've alluded to it, what is a writ of mandamus. This is a court order. This is something we haven't clarified yet. It does happen from the federal court. It compels the government entity, which is the USCIS, to properly fulfill their obligation or duties and to avoid their abuse of discretion. It's mandamus means that it is an order that is compelling action. And it also serves as an injunction, which is used to stop undue delay in this immigration process.
Exactly. And on the right here, you see that a redacted copy of just what the cover page would look like is one being filed. You can see the Attorney General, Secretary of DHS, the Director of USCIS, all those are parties to this lawsuit. Since we've been talking about it, like how is this exactly useful for immigration purposes? So the writ of mandamus existed, independent of the immigration sphere. It's used for many other things, but specifically for immigration purposes, you can petition for a writ of mandamus to compel USCIS to act, or really any government agency. For these types of cases, they will be filed in the federal court. You can file necessarily writ of mandamus in a state court, but a state court cannot compel a federal officer or a federal agency to act. So to really get the result that you want, you must file in the federal court. For these kinds of cases, they're due, or they're ripe, I should say, whenever there has been an undue delay. I've seen these for a variety of immigration cases. I've worked on specifically ones for a lot of F1 student visas. I've also seen them for N400s or I-485s, even affirmative asylum applications, although the pending time is much longer for those. You can still, I think it's around 5 years now for affirmative asylum applications. If you're just waiting for your interview, you can petition for a writ of mandamus to compel USCIS to schedule your interview.
So what are the grounds for a mandamus? And the thing to remember here is that we have to demonstrate that the plaintiff or the immigrant has a clear right for relief that's requested. We can't compel the USCIS to grant expedited services just because you want them or because you're in a strenuous situation. It must be because the USCIS has failed to uphold their obligation, which when you're looking into their rules and policies, they allow themselves a lot of buffer. So we're talking, it must be very clear. Oftentimes it's not just months delay. We're looking at potentially years in delay. We want to show that the USCIS or the defendant has a clear duty to perform a certain act in question. And so we want to show also, lastly, that there is no other adequate form of relief available to the plaintiff. We want to show that they're at a dead end. They're really waiting for the USCIS to engage in the immigration process, the evaluation process, or the adjustment of status process, whatever may apply to that particular plaintiff. And so here we're citing some, just some court language from the DC Circuit where it says, even if a court finds that all three elements are satisfied, the court still retains discretion to grant or deny the writ. And that's a really humbling and sobering message for all of us, attorneys and immigrants alike, because what we're facing here is just the sobering reality of how complicated this process really is and how challenging it is, even when you clearly are being delayed, even when you're clearly facing undue burden. And just a reminder that there is still discretion at all levels. So this is hard, but we have seen this very successful tool. So when I point out the hardships, I don't want you to think that this can't be successful or that, that you're out of hope. I just want to compel or draw your attention to just the conflicting arguments here and the conflicting point of opinion, so that when you choose to do this, if you're choosing to work with an attorney, which I would encourage you to do, you could understand why we ask hard questions or why we really want evidence to be extremely clear and extremely strong, and the kind of the push that you would receive from your attorney when trying to build a case like this. It's something that maybe doesn't always it's like anything you work toward, like you often overstudy or you often over prepare in order to draw out the most compelling case possible. And that's what an attorney would do, who was really trying to solidify a writ of mandamus case for you.
Exactly. And just to really emphasize that this is like a last resort. So some people might be watching this and wondering, like, when is the best time to file? So if you have a petition pending, for most petitions or applications, you can look at USCIS case processing times, and it has an estimate of how many cases are completed with, or I think it's 80% of cases are completed in what time frame. So if you're outside of that case processing time, I would recommend filing through writ of mandamus. But some other first steps are to do a USCIS service request about your case or petition. You can also do a congressional inquiry, finding your senator or House representatives, somebody in your district that can also look into the case on their side. Typically for writ of mandamus cases, we would use this as evidence to show that, this person has followed all the steps. They've done everything that they could possibly do. It's only in the USCIS hands now.
Yes. And so the filing of the writ of mandamus, it looks like what it looks like from, client perspective would be essentially a party's petitioning for the writ of mandamus, or the court must really file with the circuit clerk to serve it to all parties in the proceeding. That way, everybody has notice, everybody has a chance to say that the USCIS may come back and say, we thought we processed this 6 months ago. Here it is. Here's the results. It may be that simple on their side as a clerical error that may be able to quickly be resolved. So what they want to do is they want to file proper notice, make sure that both the plaintiff and the defendant are properly notified. We want the actual submission, the writ itself, to be clearly articulated as to what the issue is, what the relief sought is. Any necessary facts, like Kate mentioned, the evidence that we may leverage, really showing that this is necessary. This is, kind of the end of the journey for the client, that they're out of other relief options. Upon receiving this docket, it gets submitted to the court, and it becomes a separate court process from that point forward.
Exactly. And for the result of mandamus suit, I think a lot of clients worry, will they have to show up to court? I think most of the cases that I've seen, it is handled within USCIS because they don't want to waste time defending a lawsuit when they can really address the crux of the case internally without having to go to court. So many cases there will be case adjudication. And by saying this, you're not guaranteed a good result. The writ of mandamus is only a tool that you can use to get a result. It's not guaranteeing a positive result. So you may receive a decision on your application or petition, which may be an approval or a denial. Sometimes USCIS will transfer the case to another case processing office, so it could potentially speed up processing time if you're stuck in a district that is pretty backlogged. Yeah. Other times they'll just issue an explanation explaining why the case has been delayed. For most cases that I've seen, within, the 60 days or whatever they have to answer the reply, you'll get an email from the attorney from USCIS side saying, oh, your client has been scheduled for the I-485 interview, attaches the interview notice. Please let us know if you don't receive one in the mail. So most times they want to settle outside of court without having to go through the court process.
Yes. Can the USCIS deny the application in retaliation? So that's a great question. I think that's something that a lot of clients worry about, is would they deny me out of basically retaliation? And as Kate mentioned, it doesn't guarantee a positive result, but it does guarantee feedback, right? And she went over the options for kind of what that could look like. And because the writ of mandamus is part of the legal process, the USCIS accepts it as part of the procedure. So typically we don't see retaliation. We don't see, automatic denial as a way of just closing out the case. We don't see, automatic approval as a way of closing out the case. It still tends to be part of their process. And so ultimately the determination is typically within the discretion of the USCIS and isn't part of retaliation.
Exactly. This is just another legal step you can take. So that's what I've told clients before. I worked with people who were very nervous to submit this, but I'm like, no, this is just another tool. You're not attacking USCIS. You're not getting somebody fired. This is just another way to get a result on your case. I don't believe we had any questions previously submitted regarding mandamus specifically, but I just want to reiterate that this is a last step. If you are submitting a petition and worried about perhaps long processing times, please note that there is, premium processing available for not all applications, but for some, that is something you can take advantage of to get a result on your case within 45 days. You can also, initially do normal processing and then change to premium if possible. You can do the congressional inquiry or a case status, just to save the writ of mandamus as a last step.
We've seen a lot of success with those two steps as well. So that is worth reiterating as well, just that if you are in this process of waiting, just see if you can add premium processing to your pending application. They're not available, it's not available for every type of form, but for some, when it's available, it's very helpful to kind of push stale cases along. We've seen that work for clients before. We've also seen, I've personally seen congressional letters work really well honestly, they were trying to move along their adjustment of status case so that they could stay on some projects that were government funded, right? And so they had compelling reason. The congressional member got involved and said, hey, you know, this is a compelling interest. This is important. I can attest to that too. And it worked in favor for those clients who had that, were able to make that connection as well. So definitely, though the immigration process continues to be complicated, it continues to be changing, there are tools out there, and we encourage you to speak with our team, speak with an attorney who specializes in these areas, so that maybe you can strategize what works best in your circumstances and in your, within your timeline that you need.
Exactly.
Thank you for joining us today. Kate,
Thank you. I do see one comment from MBS asking, is 4 years a good time to file mandamus for an asylum interview? I would say that I would want to know what district or field office your case was pending out of. Sometimes you can be on a short list for an interview. Whether you have an attorney, they can advocate for that on your behalf. You can also schedule a consultation if you'd like to discuss more at rajulaw.com.
Perfect. Yes.
Awesome. And I think that is all for us then. I don't see any other comments.
Okay, I don't see other comments either. Thank you. Thank you, Kate. Thank you for having us this morning.
Thank you so much, Chelsea and Kate. Okay, and you have taken what might feel like a complex or intimidating legal process and explained it with such a clarity and care. For so many people over here stuck or forgotten in the immigration system, knowing that a legal option like Writ of Mandamus exists, right? Even I don't know. So I also got to know today because of you guys. And understanding how to use it can be incredibly empowering. So thank you so much for the very good topic and explanation.
Yeah, thank you again for having us. This was a great talk.
Yes. Okay, and okay, we can end the live right now.
Yes. I think we're good, Kate. I'm jumping off. Thanks.
Welcome to Weekly Immigration News from Raju Law, where we share important news and changes in US immigration, travel, and global mobility. Here is what's happening this week. US to require interviews for most visa renewals. Trump pushes plan to limit birthright citizenship. US passport drops to 10th in global ranking. US could lose $29 billion in tourism in 2025. Time to take a closer look. Starting September 2, the US will require in-person interviews for most non-immigrant visa renewals, including H, L, O, F, M, and J categories. This ends the Dropbox waiver for most people, even minors and seniors. unless they meet certain expectations. The change may lead to longer wait times and delays for students, workers, and employers who rely on foreign talent. Now, a controversial push that could reshape citizenship rules in the US. The Trump administration plans to end automatic citizenship for children born in the US to undocumented or temporary visa holder parents. The policy is blocked for now, but may be enforced if courts allow it. Critics warn it could leave some children stateless and create issues with passports and benefits. Meanwhile, US passport holders face another setback on the global stage. In the 2025 Henley Passport Index, the US passport has fallen to 10th place, its lowest rank since the index began. American travelers now have visa-free access to 182 destinations, down from a top spot in 2014. Experts say the drop is due to reduced US diplomatic efforts in recent years. And finally, a big warning for the US tourism industry. The US is expected to lose up to $29 billion in tourism money in 2025, making it the only country with a drop in visitor spending. Experts say Trump-era rules like travel bans and anti-immigrant talk are keeping visitors away, especially from Canada and Europe. Americans abroad also feel unsafe. With less funding for tourism, recovery may take years. That wraps up this week's immigration news. For more updates and legal support, follow Raju Law. See you next time.